Shashi, I am glad to have you on the podcast. I saw you in action recently on a panel at a conference that a friend curated and enjoyed seeing you on the panel. And then also separately interviewed Neil Chatterjee recently, and he mentioned, apropos of nothing, that you'd be great on the podcast. So this is a confluence that's bringing you here.
Oh, glad to be here. Thank you for thinking of me.
So something that's pretty clear from your career is that you've worn a number of hats, and so you've been in private practice and in a range of areas. You've IP litigation, white collar criminal defense work. You've been at a large-ish firm. You've had your own practice. You've been a U.S. attorney. You've been a magistrate judge. You've done these in different jurisdictions. So the word you used for this was nonlinear. And at some point, your career was linear. You clerked, you joined a firm, that's linear. Did you prospectively expect to have a nonlinear career?
So let me go back and correct something in my background. I was never the U.S. attorney. I was always an assistant U.S. attorney. It's a big difference in my mind. One is senatorially approved, one is not. Have I always had a thought of a nonlinear path? I would say my first nonlinear move was after undergrad to law school. I never expected to be a lawyer. And in the South Asian community at the time, there weren't many lawyers who had matriculated through the U.S. system as lawyers. There may have been some folks who came from countries in Southeast Asia or South Asia who had been lawyers there and then became lawyers here. I had always thought I was going to go to engineering school, go work for a company, and potentially then move up the ranks within that company, just as my father had did, just as a lot of other folks in my family had did. The closest thing to any entrepreneurial spirit I had in my family was folks who were physicians who had to open their own practice. So I don't think I had thoughts about what my future was going to be, whether linear or nonlinear. At any given time, it was just an openness to different paths that came along the way when I wasn't feeling particularly satisfied with the path that I thought I had wanted.
And I think you would use the word nonlinear to characterize your career. Is that something different than openness?
I think they go hand in hand. Linear is what people have in a mind of, let me take what my own linear thought was. My own linear thought was get an engineering degree, go to a company, work through the system, move around within the industry and move out and then retire. Have a good and fulfilling life that way. I have now thought about and understood for me and my personality that I had to be open to different opportunities and ideas that came along. And when some people pushed back at it, said like, are you sure you want to do that? The safe path is to stay at the firm, make partner, and then bliss will follow. And I didn't think that bliss would follow. So when I say nonlinear, it's probably more nonlinear to other people, though there are definitely risk aspects within my own life that are nonlinear. For example, leaving a senior associate position at a law firm when you're not far away from partnership to join the U.S. Attorney's Office in another state and taking a 75% pay cut. A lot of people would consider that, and I considered that nonlinear. I was leaving the safety of the firm life when I left the court to join JAMS after one term as a magistrate judge. I recognized I was leaving the cocoon, the safety of the federal judiciary to go out and be an entrepreneur. So I guess I'm a little more comfortable with risk taking. A lot of that is because of circumstances that I've been fortunate to be in where I can take those risks. My wife works, so that really helps for me to allow to take some risks.
You mentioned as associate, you didn't see a path in bliss and partnership. Why is that?
Um, at least the path that I was on, I was an associate. I had been on trial teams. What I was looking at for people who made that jump to become the lead trial lawyer, the lead um, person at the firm who gets the clients, you had to distinguish yourself in some way. Uh, and the system started changing where there were fewer and fewer trials happening at any big law firm. So the experience wasn't going to be there at the law firm. Uh, I had wanted to get trial experience, but I had also been intrigued of moving out of, I was living in Houston at the time, and exploring the opportunities outside of Texas. And that's why I joined and picked the U.S. Attorney's Office. Some folks could have said, well, I'll get trial experience, I'll join the DA's office. I wanted to do it in a different manner. I was always comfortable in the federal system because of my clerkship, the practice area I was in. And so I thought U.S. Attorney's Office was where I wanted to be. And then within that, I wanted to do more white collar work, document intensive work, rather than what would be violent crime or narcotics.
Did you or do you feel that the federal system is more meritocratic?
For the U.S. Attorney's offices, or can you give me a little more scope to that question?
Even in private practice, like, as a new entrant to litigate in, either a state court system or a federal court system, did you feel like one would give you would have a clearer path to success for you?
So the federal system is much more rules based, and there is always some level of um, vagary in any system. But my feeling was the judicial officers I'd come in contact with, both when I was a clerk and practicing, um, because it is much more rules based. I did feel I knew the the rules of the game. There wasn't like, oh well, so and so goes to lunch with so and so, so they're going to get a good ruling in state court. Not that it is like that, but I knew that was not, or at least perceived that was not the case in the federal system.
Mm-hmm. And you mentioned leaving Texas. What was the significance of leaving Texas for California?
A couple of things. First, the offers I got at the U.S. Attorney's Office were one, I'd interviewed in the Northern District of California, which is in the Bay Area, and the Central District of California. I was about to get an interview there when I accepted the offer in the Northern District. And applying for an assistant U.S. attorney's position is similar to a clerkship. You throw out a bunch of darts and see where you can get in. And I had picked 5 or 6 jurisdictions that I thought did a lot of white collar work. And the places I had also wanted to live. I had lived overseas as a child, but after high school, I'd pretty much spent my whole career in Texas, and I would come out to California with some frequency, and I really liked it. I liked the feel of the place. I liked the opportunities that were out here, but I also was lucky enough to get an assistant U.S. attorney offer from that office.
Why were you interested in moving into white collar work?
Um, it is, in my mind, it was closer to the type of work I was doing, which was commercial litigation, antitrust litigation, and IP litigation. So um, it is looking through a lot of documents. Uh, it also has, at least perception wise, more transferability back to the private sector. I had never intended to be an assistant U.S. attorney for my career. It was a period of time that I was going to, at least what I was planning on doing was go to a good U.S. attorney's office, get trial experience, do white collar work where you're also against attorneys, usually at big firms, and then go back into private practice in big law.
And why is it that you it sounds like you had some early skepticism over institutions and attachment to them. Where did that come from? Like, what gave you the point of view that this couldn't be an indefinite home for you?
I just didn't see. No, it was. I wouldn't say it's a issue with institutions. I would say it was something that I didn't see myself at that time with the knowledge I had, um, being a lifetime prosecutor. Uh, I thought it would be a 4 to 7 year term, which was very common in some of these U.S. attorneys' offices, particularly in the Northern District of California, Central District of California, Eastern District of New York, Southern District of New York. Um, it was not. It was very common to do 5 to 7 years, get good experience, work really hard, and then go back into private practice. Versus some other offices around the country where people join the office and they stay there till they retire.
So that was the norm in that U.S. attorney's office. And so then heading into it, you had some expectations of what you get out of it. What did you in fact get? What you thought you get out of it? What surprised you that you got out of that tenure?
The biggest surprise I think I got was the number of the type of people I came in contact with at the U.S. Attorney's Office and interacting with Main Justice in the 2003-2004 time period. I really enjoyed the breadth of experiences people had. When you are, at least when at the law firm I was at, people had a pretty um, common route to get to the firm. Because I was working in an IP place, it was undergrad, law school, clerkship, firm. And it was very common. There weren't a lot of folks who had, let's say, gone undergrad, then taught for a period of time, or done Teach for America, or joined the military, and then gone back to law school, and then clerked, and then come to the firm. The firm I was working at was much more um, stayed in the sense of how people got in. And that's how I saw a lot of folks at the other big firms in Houston, particularly, how they came to the firm. At the U.S. Attorney's Office, people had a lot of varied um, paths to the law. People taught, people worked overseas, people were in government at some point, decided to go back to law school, and then joined the U.S. Attorney's Office at some point in their career. So that was really refreshing to see that there was not a single path to any career goal. And I saw that firsthand with what people had done, and I hadn't been exposed to that before. It was always there are steps, and you follow those steps, and it leads to an outcome. Versus um, sometimes those linear steps aren't what we perceive as linear steps don't necessarily lead to the goal. In fact, they do because they expose you to different ideas that really tell you what you're going to enjoy and what you may be good at. So
What's
that was
another?
one of the
Yeah, what's another instance in your career where you experienced something like that, where it had a very analogous insight?
I would say I saw that at the court too, where the people who had been selected for judicial positions hadn't necessarily just gone through what you would consider the steps of going through big law, then getting on the bench. There were people who came from varied walks of life, had worked at legal defense funds, had worked at public interest entities, had worked at government entities, non-government entities, but still had succeeded in their field by getting nominated, getting appointed as a district judge or an appellate judge, and I found that was also very interesting to see.
Can you point to any specific takeaways you had from people who walked these different paths?
They learned a lot about the world, and I think it made them better people and also better professionals because they weren't thinking in the way that somebody who had just gone through school rather than somebody who had experienced the world. And I think they had brought insight that um, sometimes I wouldn't think of. And they would have experiences that were um, unique, that would give them really some idea of how to handle a situation rather than what had been taught normally. Like, this is how you deal with this. You dismiss this motion. Well, or something like that. But it gave them some flexibility and some insight on how to deal with things because I think they had a better idea of human nature.
Is there a moment that comes to mind, either from the U.S. Attorney's Office or the bench?
Um, from the U.S. Attorney's Office, I remember somebody who had been in the military before they went to law school, and we were dealing with a case. And one of the things he told me was the defense attorney was taking some positions that weren't probably beneficial to his client. And I was just having a hard time reconciling, well, why are you not doing things in the best interest of your client? I was probably naive. Well, I was naive. And he sort of explained to me certain things that go on in the real world, in being exposed to things where he grew up and how he grew up, the distrust that probably it was there between the client and the counsel because of the client's counsel's relationship with the U.S. Attorney's Office, and that we had to recognize that the client and the counsel probably had internal friction that we had to account for and give some grace to.
Mm. Did that impact you? You took on criminal defense matters through the CGA after you left the bench. Did that impact how you approach your practice?
100%. Because I appreciated that not only being a court appointed attorney may put me in a certain light in light of my client, but also I've been a former assistant U.S. attorney. And so I would recognize that folks who have been through the criminal justice system, maybe not, this is not the first time, they had, uh, oftentimes rightfully so, the hesitancy of disclosing facts to me because they didn't fully trust me, and I had to build up that trust over time. So that taught me that I had to give people space to trust me, and I also had to take actions that would allow them to trust me. It just couldn't be words. I had to act in ways that showed that I cared about their case, and that I was going to fight for them.
What specifically didn't they trust about you? My first intuition is they think, oh, you're a lawyer and lawyers are more aligned with other lawyers like you have. There's something corrupt about the nature of your relationship with, the prosecutor's office or whatever. And so you're part of the system and you're looking to take advantage of it in some way. That's my intuition. But what
Mhm.
what specifically was it that they didn't initially trust?
My sense is one of the things they don't trust is certain clients of mine couldn't afford an attorney, so under the CJA system, the court appoints you, and the court pays for it. So they are viewing it as, well, you're just part of, you and the judge are aligned, and judges in the past have done me wrong. Therefore, you will do me wrong. And that was it. That was really the first step. And oftentimes, what would happen at that first step would be you'd get appointed in court. Um, the first step in a criminal case is a bail hearing. And excuse me, oftentimes people wouldn't fight for bail, and I would always, one, I believe the law requires bail except for extraordinary circumstances. Uh, and two, I would voice that position um, aggressively. So that was one aspect. The first time they meet me is, I'm going to fight for you from day one on this case. But going back to your original question of why did they not trust me? Because I'm appointed by this judge who, and judges are all the same. They're not looking to do the right thing. They're looking to, excuse me, railroad me because oftentimes they're working in conjunction with the prosecutors.
Mm-hmm. And then what is it that you did to facilitate trust? Was there, if you had to point to one technique, one approach you use, what is it that facilitated that trust? What did you learn?
Um, to give the folks time, give my clients time. One, you have to fight for them right from the get go and be fully transparent with your client and explain why you're doing what you're doing. So, full transparency is a big thing in every aspect of garnering trust, both as an attorney and as a judge. Full transparency would happen with my opinions. I want to put in everything that I am thinking about as a basis to why I came to a decision. You'd see certain rulings that say, I find there's a fact issue, period. You're like, okay, well, you got to give me something more, like as to your insight. But giving time, giving transparency, I would oftentimes meet with my clients for hours, extensive hours. I would go meet them if they were in custody in the jail for hours, to talk with them, to learn about them, and give them the opportunity to speak freely. And the fact that I was willing to come into the jail for, let's say, 8 hours in one day and be there as long as they wanted to be there, I think showed that uh, I mean what I say. I am going to be here for you. I'm going to treat you just like back then, the $700 an hour client, as I would anybody else, even though you technically aren't paying for me. Um, you're going to get the service that all of my clients get.
It'd be pretty straightforward for someone who is trying to build a practice to say, like, that's not a good use of my time. Yeah, sure, I'm getting in court and it's a different kind of matter. And, of course, there's a number of benefits to it. But any number of people would say, like, oh, it's just not worth it. I can be focusing on that $700 client, and those are the people I'm most likely to work with in the future. What mistake were those lawyers making?
Well, I was warned about that by other attorneys in the field. Like, hey, you need to stop doing CJA cases because it's taking away from your other cases and your other marketing and hours an hour. My sense is there's a public duty obligation. And law firms, I didn't see that as much in the Central District, but in the Northern District of California, big law firms would be on CJA panels, not only as a way to get in court with clients, but also to train younger associates of interacting with clients. And rather than them sitting at a deposition and watching a deposition being taken, you could take younger attorneys to the jail cell or the meeting room and meet with clients, and you would allow them with your guidance. It's not that, oh, these folks don't matter as much. You just have a lot more freedom of and time of speaking with a client in that setting who wants to talk to you versus private clients may not want to talk to you like, hey, here's the things, get it done, give me a deliverable in 2 weeks, we'll talk then. These clients are amenable to talking with you and strategizing, and it gives you great insight as to thought processes of what may be going on with clients. So as far as mistakes of why you should do this, I think big firms should do this not only as part of being at the bar, but I think it's great training opportunities for younger folks getting in court. And being a former federal magistrate judge, I could say I would appreciate it if I saw somebody from a big firm or a medium firm or a small firm in my courtroom taking on a CJA case. My level of respect for them went up a little bit, and that transfers to other practices, and that transfers to other cases they may have.
Can you be more specific? Okay, what is the impact of that respect?
The respect is, um, at least in my mind, like, hey, you've put aside. It's not just about the dollar for you. You actually care about your client, and you are building trust with me because you're taking this thing potentially to your own financial detriment. But you are helping the bar at large. You're helping the court as well because a lot of these folks who are indigent don't get the best attorneys. By being from a big firm, I know they're getting good representation. And we appreciate that because as a judge, I wanted the parties to have good attorneys because that leads to the best outcome.
And when you say that trust transfers to their $700 clients, those other matters, like, can you be more specific? What's or tangible? Like, what is the tangible benefit for two competently talented lawyers, credible lawyers? One, you're saying earns this trust from doing this other kind of work. What is the tangible payoff to that trust before the bench?
The tangible payoff. Well, one is these attorneys who are representing indigent defendants are in court more frequently. And when I see an attorney more frequently, I feel they're less likely to play games with me because they're going to be in front of me in another case. So the tangible benefit is when they are telling me stuff, when they're making arguments, um, I am hoping, it's not always the case, I'm hoping that they know that if I catch them in a lie in this matter, or not a lie, but a misrep, or let's say misleading in a slightly way, it's going to transfer to your other client. So you wouldn't do that. Human nature is not to say, hey, I'll do this for the benefit of one, and then I'll lose my reputation for all my other cases. It's one more opportunity to build a good reputation with the judiciary.
Mm-hmm. And, with I think it's really interesting to talk about what you can, the indigent clients, have no bar. They're not paying you by the hour. So they're free to talk to you indefinitely. So you can do more strategizing. I think a reaction you could have is, okay, well, great. So you learn how to strategize with an indigent client. If someone, as you're saying, is someone who's been before judges before for other criminal matters, someone might say, okay, but like how much of the skills can transfer from like learning how to help someone who has maybe made some mistakes to a big business, with, businesses make mistakes too. Maybe that's an answer. But what is it about? It would be easy to call differences between the things that an indigent person who's had trouble with the law, the issues that person poses, and the kind of strategizing you can learn from that for some gigantic tech company or whatever. Like, what is that skill transfer of clients?
One skill transfer is learning how to um, obtain information that's relevant to the case, learning how to be patient, learning to let people speak and tell you what they want to tell you. Um, just practice makes you a better attorney. It makes you better at getting information out of whether it's the engineer who was at the bench who gave the specification for the patent, or somebody who is not trying to tell you the whole truth about something else. Oftentimes, the hardest thing to do representing a client is getting the truth out of your own client and letting them tell you what happened, letting them tell you where the bad issues are related to the case. And that takes practice. Sometimes you have to just sit back and listen. Some people are uncomfortable with silence. Some people are very comfortable with silence. I have found the higher up the C-suite, people are very comfortable with silence. They're very good. They're smart. They don't want to say more than they have to. And sometimes you have to know how to ask those questions and see the tactics that are taken in order to divert you from answering or giving an answer to the question. And folks who have, especially indigent criminals, indigent folks who have not, I don't want to use the word criminals, they're people who have done a bad thing. And one of the best lines I ever heard was, just because somebody did a bad thing doesn't mean they're a bad person. Sometimes these folks are very smart. Oftentimes they're very smart, and they've had to get by in society with wits and intelligence. And you learn things through that process that are transferable to speaking with your own clients. And oftentimes your own clients at big companies, they're amateurs considered as compared to what folks on the streets have had to do to get by.
Is there a moment that comes to mind? There's a moment of like a particularly sophisticated, someone you represent in the CGA context, and that you learn some technique, or there was something that really struck you about what they did that you use in working with these $700 clients?
The biggest tell was when somebody wouldn't answer the question in a conference room when it's just you and them. That's the biggest tell, and that's something that I learned how to deal with, dealing with my other clients. And sometimes people just need the space and the grace to get to that point in their head to tell you the bad thing. Sometimes people need to be pushed to tell you that bad thing. And I can't tell you when one approach is appropriate versus the other. It's just I've done it so many times. You kind of have a sense that, okay, if I push here, is this going to rupture the relationship? Or is this what this particular person needs?
Is there been a moment where you've taken something that the client, in any context, these indigent defendants or big companies, is there a time you've taken something that they deemed or was objectively a bad fact and inverted that into something that was beneficial or at least neutral, at least neutralized that bad fact?
Um, I would say in certain white collar cases I had in the past, and even in civil matters, and particularly in mediations, I'll do this quite often, which is the other side will rely on a document that they say this is a bad fact, and you're speaking with the client. And one of the mechanisms to really understand whether it can be neutralized or at least diminished in impact is give me the context of this document. And that allows folks to then discuss, no, this document isn't as bad as you think. And I will tell me why. And being able to just sit there sometimes for, it doesn't sound like a long time, but for 5 minutes in silence while that person is talking. You do this, 5 minutes of silence is a long time. But just sitting there and let the other folks speak, sometimes they will give you the answer that actually does neutralize it, or in their explanation, they come to realize, yeah, this is a bad one. So they internalize the aspect of the document that's going to be harmful to them without me having to tell them.
Mm-hmm. I want to go back to something you said about the nature of the CGA panels in the northern districts versus the central district, and you found that the large firms, that part of the bar was much more active in the northern district. You've been prosecutor, you've been magistrate judge, you've been in private practice, across two jurisdictions, and maybe from anywhere else in the country, they might say, okay, northern district California, central district California, sure, there's differences, but they're more similar than dissimilar. What is your vantage point on that? Like, how can you help people understand? Hey, yeah, of course there's similarities, but there's actually a lot more differences across districts than you might expect.
It's when you say differences across the district, you mean in the judiciary or the practice? What do you what would you like me to focus on?
Because you straddled a few different roles, you've been, before these in private practice, you've been on the bench, you've been in the prosecutor's office. So it's really, you've got multiple vantage points on differences and patterns among these jurisdictions. So, you pointed to the bars, the big law bars, participation in CGA, and that impacts, culture. What are cultural differences among these districts? What are the natures of the kinds of matters that are prosecuted from the U.S. Attorney's Office? What's your relationship with the bench? There's lots of jumping off points, and I'm curious, whatever's top of mind for you,
Sure.
in comparisons between them.
Sure. So for let me take the Northern District first. The Northern District of California is a lot more tech heavy. Down Silicon Valley, San Francisco has historically been a financial center. Uh, as you probably know, Wells Fargo, Bank of America, they were all based there, but now they've moved their headquarters elsewhere. But there is a tradition of a lot of financial um, businesses as well as tech businesses up in Northern California. Northern California also had an SEC office, as does the Central District. They have a culture of prosecuting certain types of or investigating certain types of allegations. San Francisco has an antitrust division office. Central District does not. So as a result of certain offices that have priorities in those particular jurisdictions, the practices I think have um, morphed to accommodate those enforcement areas. So San Francisco has a lot more private antitrust cases, I understand, than the Central District does. Uh, Another district that has a lot of antitrust cases is Eastern District of PA, Philadelphia. And how those formed over years, I'm sure there's multiple reasons. Um, but at least in San Francisco, they had an antitrust division office there that was enforcing antitrust law. So you have law firms that create and respond to that practice area. Um, Central District, California, it's just huge. It's massive. It's 19 million people. Northern District isn't smaller. I mean, isn't small, but it's not 19 million people. There are a fair number of historically um, uh, narcotics and violent crime uh, prosecutions that were done at a larger scale in the Central District of California than in the Northern District of California. So um, you had differences in practices of the prosecutors and the type of investigators that would then come to these jurisdictions who would investigate cases for you. And so from the judiciary standpoint, you would see different types of cases because ultimately we're the client. We were um, the attorneys are our clients when I was on the judiciary, and they bring you the cases they bring you, and you deal with them. So in the Northern District, you would get a lot more IP, antitrust, and the SEC. Though there would be some what I would call guns and drugs and violent crime, it's not nearly as much as the judges in the Central District, in my mind, have to deal with. Though you could take a look at the statistics, and it may not be borne out. It was just my experience that the judges up there handle a lot more white collar and IP, SEC, antitrust cases. In the Central District, you have a lot of contract cases. Just because there's a lot of commerce down here. Not only is there commerce related to contracts, there's commerce related in the entertainment industry. And that is a big aspect in the Los Angeles courthouse. In the Orange County courthouse, we had there's a lot of real estate related businesses and IP because of the companies that are based in Orange County. Riverside has a lot of contract, commercial matters, as well as a lot of civil rights investigations, just because of the nature of the population. So even within the districts, the divisions have a different sort of focus because of the types of cases that are generated within the counties that comprise the particular division within the district.
And so that's really helpful to understand how these, kind of patterns or pockets of expertise that form impact components of the bar. So you've got, you describe the impact of the expertise that, a U.S. attorney's office might have, the impact that has in the private bar. What's the impact on the judiciary? What is the consequence of expertise, or is there something in the nature of resolving contract disputes? If 80% of your docket is contract disputes versus 80% is IP and antitrust, what's the impact on how judicial opinions are formed, or the approach of the bench and the relationship with the lawyers before them? Like, what changes for the judges as a product of these pockets of expertise?
Yeah, I can just speak to myself, and what I would see is there's different ways to the way you manage the case is different based upon the nature of the case. If it's a let's say a PI case, a personal injury case involving, we would have certain sometimes trucking accidents in federal court because they would get removed based upon on diversity. There's a different way, there's going to be a different discovery, different timeline to get that case to trial versus an IP case, which may have international components. There are going to be different motions, different discovery aspects. And the more you see of a particular type of case, the more you can anticipate what problems are going to arise and how to put in safeguards in the management of the case to allow that case to proceed more efficiently. Let me give you an example. For example, in a big commercial case, IP versus a relatively, let's say, two defendant contract case. Okay, I'm sorry, a two-party contract case versus an IP case. And let's say it's a fairly simple home construction contract versus an IP matter. One of the things you have to be mindful for in either of those cases is what's the scope of discovery and how is that going to impact the deadlines that you're setting for summary judgment and the trial deadline. Should you put in a end of discovery date, or should you put in a date before that constitutes what's called a substantial production of discovery deadline? Because there may be lingering things that happen after the discovery has gone out. Well, we've had to work with our client in a different country that has different privacy laws, therefore we couldn't provide this material now. Whereas if it's a contract case involving two parties locally, it's going to be a pretty finite sense of a finite amount of material that's going to be needed to present that case to a jury. So the more you see of a particular type of case, the better you can anticipate the problems that may arise in managing it.
Do you think there's a benefit to codifying that in some way, and so that sets a norm for peers on the bench? Like, what are ways to institutionalize this knowledge?
Well, certain courts have local rules for patent cases, for example. The Northern District does, the Eastern District of Texas, the Central District of California there's been talk about that for now decades, and they have not been adopted. But what will happen sometimes is a party will say, if the parties will agree, they'll say, well, Your Honor, we'd like to use the Northern District of California rules for patent cases in this matter. Some people like that. It codifies it. Some people believe it takes away the bespoke handling of every particular case. So you have voices on either side, and fundamentally you can't make judges do something they don't want to do. It's very difficult to say. You need a consensus to make that the norm within a particular district, and it can be difficult because people have valid views on both sides of, well, will this inhibit my approach to a particular case? Let's say it's a really simple patent case. Why should we have all these rules that are more favorable to potentially, let's say, the defendant? So that may take away some freedom to manage that particular case in an efficient manner.
So what I'm hearing is, well, I first want to mention on this impact of procedure and process is that something that's been a running theme of this podcast. It was first raised by Judge Kennelly in his episode, and so he talked about the centrality of process for the administration of justice. Judge Chabria picked up the same theme as well. So this is, I think, it seems to me an underrated theme from the judiciary is the role of process in the administration of justice. And so the other thing I'm noticing is you're saying, and this is something Judge Kennelly also noted in his episode, is the pros and cons of how independent every judge is for the same reasons you're identifying. It was part of Judge Chabria's episode because he and one of his colleagues came up with different approaches on an important issue on AI and fair use recently. Mm-hmm. So, but it seems to me that there's this trade-off between standardization and customization for a particular matter that judges have to consider. Like, judges form their own points of view on where they sit on the importance of one or the other. It seems to me that's a canonical trade-off that judges consider. Are there other canonical trade-offs that you can identify that judges consider?
I guess I'll ask. I don't know what canonical trade-offs mean.
Boy, I feel like before your courtroom right now. So, look, it just seems like one of the classic issues that you're saying that a judge has to consider is, to what degree do I think that a type of matter is more amenable to standardization, or to what degree do I feel like, hey, it's more important to have every matter before me and just make a call on each one of these.
Mm-hmm.
Those are trade-offs. There's benefits to one approach, there's benefits to another, there's costs to both approach. What are other benefits and cost trade-offs that judges consider? Like, what do you consider as, like, when you're sitting in a room with your peers, what do you think are the tension points where reasonable minds, experienced minds can disagree on this? Seems to be an important one. What are other important ones?
Okay. So let me, one of the things, because I was a magistrate judge, I had a lot of discovery matters. There are certain viewpoints in discovery, which is, look, that's the attorneys, they'll deal with it. And when they have a problem, they'll bring it to us, versus putting in procedures to avoid those issues being brought to you. So let me give you one example. Depositions. If a party had consented to me, and so I could control a lot of the discovery issues at the beginning of the case where you would have your conference, I would adopt the rules with respect to objections at depositions from the Eastern District of Texas, which were, you can only object to form, or you can only tell your client not to answer a question based on either attorney-client privilege or the attorney work product doctrine. Or you could ask the other party, the party you were questioning, you could submit the objection of non-responsive. So that does away with speaking objections. And in California State Court, they are supposed to do that. You're supposed to do form and only be able to instruct your client to avoid speaking objections. And then if you object form, the questioning attorney has the ability to ask you, well, what's your basis for that objection? And you would have to say, lacks foundation, hearsay, whatever the evidentiary basis is. Certain judges would say, like, we're not going to put in this controls of the deposition should occur. I had enough issues come up before me with speaking objections that were taking the depositions beyond the 7-hour time limit and things of that nature, that I thought it would be helpful to the counsel to say, here are the rules. You're gonna have these are the only objections you're gonna have, and then I don't want to hear, or I think you have less of a leg to stand on saying, well, we didn't get all the information we needed in the 7 hours that were allowed for under the federal rules, and we need more time. So there is an involvement in sort of the process that I thought would be beneficial to what I viewed, again, as my clients were the attorneys and at the bar. And other folks said, look, we're just refs until we see a foul, we just sit back.
Any number of people. So my experience with magistrate judges is yes, they're feeling so much of the discovery issues, across jurisdictions. That's something I observed. What is, Article 3 judges are obviously, the flashy role. Like, that's just like, that's, kind of the role that people, have in mind when they think of judges.
Sure.
What do you think people are missing from the opportunity of either being on the bench as a magistrate judge, practicing for a magistrate judge, clerking for a magistrate judge? What do you think is underrated about that part of practice?
So let me first start. The role of the magistrate judge is changing. A lot of districts now have consent programs. The Northern District of California has historically had a consent program where it was, I don't know whether it was considered bad form or why, but when a case is assigned, if it got assigned to a magistrate judge in a civil case. Now, criminal cases, they have different issues because of the Constitution and who can impose sentence on a felony. But in civil cases, a lot of parties will consent to magistrate judges, and that's becoming more common in the Central District. It is very common in the Northern District, and I can't speak intelligently as to what happens in other districts. So the role is changing. From that standpoint of being an MJ, I think it's a great opportunity. It's a great job. It's great from a standpoint of you're in the federal system. You are getting a lot of consents. You are dealing with a lot of the nitty gritty stuff that happens in cases that actually can help form and moves the process along in an efficient way. I thought it was a great opportunity for me to learn also how the how to think like a judge and what is really going on behind closed doors. What's the thought process, even beyond clerking? I'd clerked for a district judge, and so when I became a magistrate judge, I had a sense of what happened, but not really. You don't know it until you do it. There's and one of the other things I can speak at least um, to the culture in the Central District of California. Um, the magistrate judges and the district judges, we interact fairly regularly. There was no sort of in certain courthouses or the vast majority of people, there was no distinction. It was like, oh, this is Judge so and so. Nobody, you would not hear a district judge say, "This is Magistrate Judge so and so. I'm District Judge so and so." You just didn't hear that, and so you get a lot of insight into the whole process. As far as clerking for a magistrate judge, I just got off the phone with a former clerk yesterday who was arguing with his law firm because somebody had wanted to go off and clerk for a magistrate judge. And the biggest thing was like they will become a better writer because of the product that we have to get through, especially in the busy districts. How many motions we have to decide, and it really trains you to become a better, more efficient writer and gets to the point of what you're trying to convey. You get to see a lot of um, argument by attorneys. You get to see good, bad, and you get to see a lot of other materials. And just being in a courthouse, you pop in, it's like being a gym rat. You're at the gym and you can pop into a courtroom and see, like, oh, we hear so and so is giving a closing in this matter. Go check it out. And so there's access and there is um, the opportunity to really improve not only your understanding of how the judiciary operates, but also to improve your skills as a writer.
To that end, what surprised you the most about how the work that judges do, either in opinions, either in administration of cases, like maybe any of these, but what surprised you the most from your time on the bench?
The volume of cases that we have to deal with and the number of complex motions that we have to address in a timely fashion in order to really deliver justice to the parties. You hear and you're like, oh, we have this many cases, but until you're there seeing the flood and the type of cases, um, so security appeals, bankruptcy matters, the most complex issues oftentimes were in pro se matters, particularly pro se 1983 cases, because they were, a party would use some loosey goosey language, and then we would have to ferret out, hey, what's the constitutional basis for this? And I remember and as a magistrate judge, we would have to screen these complaints, these 1983 complaints from oftentimes prisoners and pro se folks, um, which have gotten better with AI, by the way. But nevertheless, it is still complex because I remember handing a complaint to my law clerk. I go, "Here's your new con law exam." Like, what are they? Gideon versus Wainwright was a pro se person, and these complex constitutional um, ideas and the theories of recovery are oftentimes raised in the most mundane and surprising ways. And so you would see that in cases where, hey, they didn't let me out of my jail cell for blank number of hours. And the other side says, well, there was a lockdown, so we don't have to. It's like, okay, well, there's constitutional tension there. And those types of cases were the most surprising to me, of the areas of law that you had to get um, quickly up to speed on. Uh, Even with most law clerks are 1, 2, or straight out of law school. And yes, they may have some ideas, but you've got this breadth of knowledge, and it's difficult. It's difficult one day flipping from an ERISA case to the next moment talking to a Fourth Amendment issue that's a little quirky.
That's profound that from the bench's standpoint, the bench is not assigning significance to cases based on dollar value or something like that. It's based on legal issues. And so, as you're saying, like, some seemingly minor pro se case could raise such interesting constitutional issues that, in the case of Gideon, just transforms our legal system.
Right.
Yeah, that's interesting. That it reminds me of, the previous episode was with Louis Tompros, very different context, but he identified an opportunity to look at pro se patent application filings and rejections,
Oh,
and look for ones that had raised interesting legal issues that then he could argue at the federal circuit. So he took one on pro bono. It's called In Re Klein, and so it involved the doctrine of obviousness in the wake of the KSR Supreme Court decision, and got a presidential opinion out of it, changed the PTO's examination policies. So these seemingly minor matters can have a big impact.
sure. Yeah.
So from the bench, you're mentioning, you're like a gym rat, and there's so many, like in the gym, there's different theories for what's effective, and different things work for different people. People with different physiques and strengths and et cetera. So there's when we hear about advocacy techniques, I think most commonly we think of a one size fits all approach. There's just some objective, platonic, ideal way to communicate before the bar. Sometimes you hear, like I think particularly in the context of the Supreme Court, you hear such and such advocate. Well, they can get away with that because they're blank name. They can do whatever they want up there, and their approach. And so in some sense, it's just like, maybe it's extremely personality driven in one sense. On the other hand, there's like just these perfect approaches. I imagine that the truth is somewhere in between. So maybe it's certain advocacy techniques apply to certain personalities or certain types of matters. What can you say about what you learned about advocacy techniques from the bench? What changed your mind about advocacy? Because you had plenty of experience before that in private practice as a prosecutor. What changed? And what, do you feel like there's archetypes of advocacy techniques?
So let's split it into two types of advocacy. One is advocacy to the bench in a legal matter versus advocacy to a jury, and what works in both cases. With respect to the bench, the common theme that I saw across every advocate was they answered the question. First thing out of the box. They didn't want to preface it with a bunch of stuff. They answered the question, then they would give the explanation. And that was really appreciated, and that set somebody head and shoulders above the next person. Within that answering of the question, and it could have been, it's like, well, it depends. The most lawyerly of all answers. Well, it depends. And then the next question you could anticipate from the judges on what? Right. If we're going to go down this flow chart, let's create the flow chart. And the best advocates would take you down that flow chart. The people who weren't that good would not. They thought, oh, well, I'm not going to get that next question or anticipate that next question. And it would quickly fall apart. All of that is wrapped up within credibility. As a judge, and this is what I found myself doing, you would oftentimes find within, let's say there's 4 attorneys there, 2 on either side, the attorney you could trust the most. And the attorney who gave you that direct answer quickly with supporting basis, either legal or factual. It all comes down to credibility, and who am I going to trust when I don't have everything in front of me, and these people are representing, these are what the documents say, or these are the amount of documents that we have to deal with, versus somebody else saying, oh, we have a lot of documents. Like, how many? It's like, a lot. It's like, okay, that doesn't persuade me. So the folks from a legal standpoint would first answer the question, would be succinct, not necessarily succinct in the sense of not give you the requisite detail, but would often then sometimes put in a little ad hominem attack, or would put in why this case is so difficult, or something else that's like um, just not related to the merits. Um, and they would give you that answer, and sometimes they would give you the answer that's harmful to them. It's like, well, no, we don't have that. And that again builds credibility, which is the cornerstone of everything. If you lose credibility, you're pretty much done in arguing before a court. I could say that pretty much across the board. I don't think any judge would say, "Oh, well, if even if you're so and so big name, if you don't have credibility in front of me, I'm still going to give you a break." It's like, no, it's not gonna happen. Um, so that's legal argument. Um, in front of a jury, uh, what I found was there is no archetypal uh, manner. People who you would think were like, God, the person's just not prototypically, quote, smooth, but they are winning day in, day out in front of a jury. And I think that comes from genuineness uh, and authenticity to yourself as to what type of person you are. The bigger thing is not being a jerk. Juries pick up on that. Judges pick up on that if you're just a jerk and mean, um, versus fighting for your client. You can do the two things without being a jerk. You can fight for your client hard. Um, but I don't know if there is a single type. And with juries, again, I think if you get caught misleading or misrepresenting something, particularly a document, it's hard for you to come back from that.
Hmm. You mentioned what you learned on the bench as a judge. I'm curious about what it's like when you first get on the bench. I imagine early on, you're like, okay, I'm learning the process. I'm learning what a judge is supposed to do. Of course, you had some indication, you had some guidance heading into it. Was there an early moment where, you maybe you go from doing the work of a judge to feeling like a judge? If that's true, what was the moment you experienced that?
So this was an important thing to me. I never wanted to get wrapped up feeling like a judge. Um, there's I maybe this is not true or not, but there's a story of the Roman emperors would have always somebody whispering in their ear. And I'm not saying a judge is a Roman emperor, but there is such a thing as robitis. And people start to believe, oh, I am funny. People laugh at my jokes. Oh, I am smart. So I would affirmatively take steps to, for example, my clerks outside the presence of other judges and not at bar events, I'd ask them to call me by my first name, and I'd say it's a security issue. I don't, if we're going to lunch someplace, I don't want you to call me Judge. Just call me Shashi. But those were little steps that I took, and I think I went through my whole career with some level of imposter syndrome of thinking, God, there's other people who could do this, and you get comfortable with it to say, like, no, I can handle this job just as well as anybody else can. You get comfortable with that. But I would always keep in mind that my job as a judge it was a temp position I was holding. If I retired or if I passed, my chambers would go on to somebody else and I would be forgotten maybe a year later, tops. That's just the ephemeral nature of the world. So I was mindful that I was a public servant. My job was to consider and continue to serve my clients, which are the bar. And I would remind myself of that and remind all our clerks, like, we are not special. We are all replaceable. We have a job to do. And so I never tried to deviate from what my job was, which was to provide timely, efficient, well-explained reasons in a ethical manner. I was a public servant that happened to be in the role of a judge. So I tried never to become like when you say, oh, you feel like a judge, it's like I think I got better at my job because you would see things over and over again. You build up a database, um, you built up knowledge on things that could go wrong in case management, or when I would do a lot of mediations, like things that could go wrong, or what would be pressure points that would help in resolving a case. But I never really felt that being a judge was something special. As it was more of a privilege for me that people had said, "Yeah, we'll let you be the ref for these games."
So you mentioned in a couple of different moments. One moment you mentioned that, look, that so magistrate judge often, yes, there's matters that are before them by consent, but then also they handle lots of discovery disputes. Also, of course, settlements are often referred to magistrate judges. So there's and then you also mentioned that depending on the district, there's different types of matters. Maybe one jurisdiction is contracts, whatever. So apart from those aspects, is there something generalizable about that we were talking about advocacy techniques and the degree of generalizability there are? Was there something about decision making, maybe generally, maybe it's specific to types of matters, et cetera? Is there something about your decision making process that you honed from your time on the bench?
Yes, for sure. I mean, at some point, as an advocate, you know what your position is, um, and you are forwarding that position with a larger strategy in mind. Um, as a judge, one of the things you would try and separate is the effect of your ruling in the sense of like, oh, well, I don't like this person, or I like this person. And you had to separate that from the ruling that you had to make in front of you. It was very much a chips fall where they may attitude. And Michael Lewis had a podcast. He does these podcasts, and one of them was he does a very series. He'll do like a series over one season. I think season 2 or season 3 was about the rule makers. I'm sorry, the rule enforcers. It was about judges, and it started off with refs, and how we have changed as a culture of attacking the ref. Whereas before we didn't as much, right? You hear in any baseball game or basketball game, it's like, ref, you suck, and you'd hear things like that. Judges are refs, right? And so it permeates through society when a judge makes a ruling that, oh, you're doing it for some nefarious reason, or you suck, and therefore we don't have to follow it, or etc., things of that nature. Um, so I was mindful that I'm not the player here, but I have a role to play, which is I make my ruling and the chips fall where they may. So you have to get comfortable with that. You're going to displease somebody. And I was, uh, one of the things in writing that you change is um, I would write very, very dry, because you don't want to give any indication that it was based on personal animus. And you actually, you, there's this thing, it's like, right, do good deeds, say kind words, think good thoughts. I think that's a Parsi approach to life. But the hardest thing to do is think good thoughts. But you start that by acting and doing good things, and then hopefully it ingrains in you where you start thinking good thoughts. So the performative leads to the substantive. Saying things kindly, being polite, being measured, then you start thinking that way. So you have clerks saying, oh, Your Honor, it's like this guy just lied about the facts. Like, yeah, I get it. Like, because he blatantly lied. It's like you would rewrite that. I would rewrite that as saying, uh, counsel counsel does not provide proof for this statement. How looking at the evidence, however, comma, you move on. Right? You don't need to comment on what somebody did or how they did it when you have the power to make the ruling. There was another, I guess, there was an NBA ref who his dad was a Chicago PD, and he said, "Yeah, I learned a lot from my dad, who was a Chicago police officer." And he said, when you have the last word, don't say the last word," which I thought was telling. It's like I don't need to be snarky or anything. this is just the ruling. It is what it is. And so I thought that was something that it was in my nature not to be snarky. So this came easier to me, but it was still something to be mindful of in any writing, especially when certain counsel would flat out lie about what a case said or what happened in court.
Is there a decision that you're most proud of?
I would say no, I don't think there's a decision. I think what I'm most proud of is that when I was on the bench, particularly um, in criminal matters, when there were folks before me in detention hearings and bail hearings, um, I I heard comments from certain attorneys saying, "Hey, even though you detained my client, he really appreciated you listening to him or her." The fact that I gave everybody, or I tried to give everybody, the respect that they were due, um, and didn't and tried actively to suppress any ego I had. I think that has helped me not only as a judicial, helped me in the past as a judicial officer, in private practice now, and has made me a better person at home. Um, because you do have to internalize suppressing your ego. I didn't view myself as the most important person in the courtroom. I was there, but it was the client's courtroom. And when I say the clients, it's the attorney's clients. It's their courtroom. We just happen to be there to facilitate the resolution that has to happen.
What were the experiences you had before a judge that helped you get reps in with suppressing ego?
There are certain judges who I would model myself after, and these are folks who are highly accomplished, but you would meet them and they were just the most humble people who you can imagine. Like in the Northern District in particular, everybody would hold up. There's a judge named D. Lowell Jensen. Judge Jensen he was a prince of a man. I tried cases in front of him. Um, he was just, but I remember when I had a 2-year-old daughter, or maybe she was one, we were in a mall, and I hear this Shashi, and he was really nice because he would say my name correctly, which was nice. He'd be like Shashi, and like Shashi Kewalramani, like he would say it perfectly, and because he took the time to learn, like how do I pronounce your name? And he was an institution. I don't know if you've heard of Judge Jensen up in the Northern District. He had been the former district attorney of Alameda County. Um, he had actually then become an assistant attorney general under under Edwin Meese and Ronald Reagan, even though he was a Democrat, registered, I believe, at the time. And then he got back on the bench, and he was just he was an institution. But he saw me at the mall. He's like, "Hey, Shashi." It's like, and I looked around. I had my 1-year-old daughter in my hand, and he's like, "How are you doing?" It was like, but he was just that type of a guy. There was no ego. And I was like, "Oh, Judge." He's like, "No, no, no, no. It's Lowell. It's Lowell." And and everybody would clamor to get in his courtroom. Like if you could get a case before Judge Jensen because of the way it would be assigned, it wasn't going to be easy, but it was going to be fair. And that was so there's certain officers, judicial officers who I would see all the time who were just very kind, would let you know that, yeah, they were credentialed, yeah, they had experience, but there was a an aspect of just serendipity to where they are, and that was a recognition that I really tried to internalize.
Let's talk about your transition to private practice as a mediator.
Sure.
Of course, this is not rare for someone to go from the bench to mediation. It's not rare to go to a place like Jams. What about? I think something that maybe takes a little reflection to notice is that when you're on the bench, you mentioned rules. There's rules, and as a part of those rules, you are able to make determinations that are binding on individuals. Mediation is different. You mentioned this concept of taking deeming a client-centric approach. Obviously, as a judge, you don't have clients, but you deemed to have this approach to help you contextualize how to approach. Now you have clients. So what are the skills that transferred from the bench, and then what do you think is the biggest departure?
Um, so what transfers from the bench first? Let me take first the skill sets within that. Being trained to listen. Some people have it innately, some people have it naturally. Um, I had to work on mine, and I think I got much better at doing that as a judge. And before that, I think I got much better doing that as a criminal defense attorney. So it's a constant evolution towards being better in a particular way. Recognizing what transfers, recognizing, um, let's say in a criminal defense setting or even in a civil case setting, when I was on the bench, I would be very mindful of anything I said about counsel, especially in front of their client, and also in any written opinion that I would put out. Because um, let's say a criminal defense attorney is making a bad argument, and I said, I can't use the word, well, that's ridiculous. I would be mindful of making any comment or things of that nature because it could harm the attorney-client relationship. Similar in a civil case, I appreciated if I said something, well, counsel has misled me or things of that nature, that order sometimes had to go to in-house counsel. In-house counsel would then see, oh, maybe, or read into it, well, this judge doesn't like this attorney anymore. Maybe I need to find a new counsel. So my words had ramifications beyond just what's said in the courtroom. And I trained on that. I got that really became internalized, so that if I was thinking something, you just keep it to yourself. And oftentimes, upon reflection, it goes, the attorney's argument wasn't ridiculous. I hear where they're coming from. So it really trains you to sort of um, uh, be a little more mindful of your own prejudices and biases and sort of tamp those down. So that has transferred well into private practice, which is, and when I go, so there's mediations and there's arbitrations. Arbitrations, there's the same thing. I'm in court essentially. So I'm very mindful and measured in whatever I say there. Um, and I think I've become more mindful and measured in how I think. Um, so those thoughts don't pop into my head. In a mediation, I appreciate that the same things where I have to maintain um, my relationship with counsel, not just as a business generation aspect, but rather in order to get a deal done, I have to empower. My jury is the attorney, because when I'm in the other room, or she's in the jury room with the client trying to say, well, what the judge said was kind of, it makes sense. I need to empower somebody and give them the ammo to persuade their client why they should resolve the matter in a particular way. So that's mannerisms that I think have transferred from the bench, and thought processes that have transferred from the bench to my mediation practice. Um, the biggest difference is, um, gosh, there's the going to, let's say, just bar events. I used to go to a lot of them anyway because I felt it was important to have a South Asian federal judicial officer at as many bar events as possible to see, hey, our benches, we were ambassadors for the bench as well. We have a diverse bench, we have different viewpoints, and it was a great way to get intel from the bar as to what we could be doing better as a judiciary to service the bar. Now at the bar events, uh, people aren't coming to talk to me. They know I'm a former judge. I'm essentially a vendor. I get that. And so I appreciate that my role is now to be a little more proactive in speaking with people. The marketing aspect is a little different as to uh, how I approach people, in the sense that you just have to put yourself out there a little more, whereas I didn't have to when I was sitting on the bench.
What's been hard about that? What's been surprisingly easy about that?
Um, Hard. I'm still surprised at how people, certain attorneys, don't respond to emails or don't respond to text in a timely fashion. I'm still surprised by that. Now, I have a theory that has been borne out, which is the most successful attorneys who you can think of, like the biggest names, they're actually the most responsive. There's a direct correlation between people who are successful and responsive, is what I'm seeing. Whereas when you sent an email from the bench or from the court, it's like, oh, you'd get a response back fairly quickly. And so that has been surprising uh, to me, of like, wow, people just don't respond. Interesting. And I'm wondering, you see, and I think clients see this, if somebody's more mercenary versus others, like, oh, they're only talking to me because I need something from you today, versus, hey, I'll talk to you just because it's the right thing to do and be polite. If you say hi, I will wave back hello. Um, the easiest thing for me has been, I think, just because of my involvement in a lot of bar activities before I was on the bench, it's been relatively easy for me to reach out to networks that I had been a part of before I was on the bench. Also, um, it's been pretty, I just, it's easy for me to go out and grab lunch and talk to people. I'm lucky in that regard, where I'm not as introverted as I thought I was. Uh, and so that has been relatively easy to. And then the other thing has been, because I did a lot of mediations on the court, reaching out to folks who I did mediations for and getting such a positive response saying, like, hey, and I tell them, it's like, look, when I could have been the biggest jerk, you saw what I was in a mediation and I wasn't. So what do you think I'm going to be out in private practice? Like, I'm going to be forceful, uh, but always polite, like I was on the bench, which I think people sometimes like to have in a settlement conference. They don't want a note carrier. Susie thinks they're cute. Well, Tom thinks they're cute too. Like, they don't. There's no value add to that. Um, this actually relates to my position as a judge, which is, I'll make a call. Like, I think this argument's strong. I think this argument's weak, and they may disagree with me, but you got to make a call, and that's a value add, and that's a deliverable that I can give to any of the attorneys to take back to their clients in determining whether to resolve a case.
You mentioned so one thing that you are doing to position yourself is point to your experience in the bench, point that you have mediation reps from your time on the bench. You also point to your approach, that it was like, you strive to be civil and effective on the bench. How else are you thinking about positioning yourself? Because there's a number of other judges
Sure.
and jams. What do you view as your core differentiation? How are you? Is it an aspect of niching? Is it an aspect of practice area? Tell me about how you're thinking about how you're differentiating yourself.
Um, so there's the showing and versus saying aspect. Let me go to the showing aspect. In every mediation, one of the things, how do I differentiate? I prepare a lot. And I think people see that when I know the details of the case, and I appreciate the effort that I put into it. Uh, a lot of mediators do that. And I think there's a huge bell curve within the mediation business of, there's a big middle, and there's smaller tails on either side. I want to be on the smaller tail on the good side. And part of the differentiation is, I have the background in IP. I have the background in complex commercial cases. I did a lot of securities work, and I have a very good understanding of federal statutes. So I'm positioning myself more as a commercial and federal person, rather than, I'm not your best person for um, a a car wreck case and evaluation of soft injuries. I can help in that regard. I've done a lot of that, but my positioning is going to be in more commercial IP securities types of cases, trade secrets, those things, those natures. I'm not. I can do others, but I think that's where my sweet spot is. So that's how I'm trying to position myself as compared to a lot of the other mediators. Um, and frankly, my rate is going to dictate that as well. I'm not going to get a lot of the lower dollar value cases because of my rate tends to be a little higher. So that's how I think the differentiator from other folks. And um, as far as other judges, there are I've tried cases, and there is a difference between having been a ref and or being an ump and being in the batter's box. I've tried like over 15 cases, and so I understand. I've had private practice, so I understand the pressures counsel are under, as well as giving them an insight into how certain arguments may play in court.
Mm-hmm. When I'm curious about the ways in which mediation maps onto partnership. What are so one thing we already talked about is niching. That's obviously large law firms or boutiques just people specialize, and so we're already starting to talk about specialization a little bit. Another dimension of practice is thinking about size of matters, and there's trade-offs among those. So you can work on high stakes matters, but it's there's some constraints you're operating under there, or you can get let's say there's fewer of them, right? So there's you're chasing whales, or you can say, hey, I have I want to work on a higher volume of there's middle market, there's smaller matters within the band of your comp, right? So
Sure.
there's different approaches you could take. Do you have a preliminary view on how you're thinking about the type of matter that you're taking on?
Sure. Yeah, I'm very mindful of that as well, which is the niching versus a broader based approach. So in the commercial world, particularly not only just contracts and securities and IP matters and trade secret matters and those things, I think there's a lot of those cases out there. And frankly, the dollar amounts that are at issue, they don't have to be that high to warrant retaining someone like me. So let's say if you're looking at damages above $2 million, there's a lot of cases like that out there in the commercial realm. And so I don't feel that I am restricting myself to a small, like, I'm not looking for, like, I need 3 mass torts or 1 mass torts matter a year. I can do that as well. And I have been retained to do some of those. But the other matters that it's interesting that it's sort of like the practice picks you, where I have resolved cases for particular law firms, and now they're coming to me with slightly adjacent subject matters to the subject matter I help them on. And the response I'm getting is, we just want somebody who's well prepared, is going to dig into the details, and the dollar amount meets what we can then tell our client, hey, he's worth it for the day. And I was talking to somebody yesterday, and on average, even though I'm hired for the day in mediations, I end up spending about 20 hours per mediation on prep, the mediation itself, and then post prep to get the deal done. So I don't feel I am narrowing myself to an area of practice or the types of cases that are equivalent to chasing whales.
I think another aspect of practice we can compare to practice at a law firm versus mediation is what you already referenced, is this concept of repeat business. So I think there's trade-offs to having a whale client that you do a lot of work for versus you're diversified. And somebody put it to me that a patent litigator said, hey, sure, maybe I'd like to have some big tech company as a client, but then how do you say no to that 19th, 20th case, right? Like you kind of have to keep on dancing as long as they say dance, right? So it's like a drinking from the fire hydrant kind of aspect to it.
Sure.
So how do you think about that as well for your practice? Like the trade-offs of maybe having a roster. Let's say one approach is getting 80% of your work from 3 firms versus being diversified. Like, how do you think about that trade-off?
I'm mindful of that, and I want as broad a roster as possible. And so I'm not just focusing on big firms. I have a lot of colleagues in cases who I've done resolutions for at smaller firms on the plaintiff side. And where the business comes from, just like any marketing, you don't know where it's going to come from. You just need to put as many seeds out there, and you don't know what's going to bear fruit. But I am mindful that I am not just catering to big firms. They don't have they may or may not have as many cases, and that just doesn't seem to be happening. And that's my experience, at least in the mediation world, where yes, certain big firms will keep coming back to you, but the counterparty may be different every time. And so then the counterparty, if they like you, they'll start hiring you. It's sort of like this web that grows out. At this point in my career, I'm just looking for as much exposure to anybody to see so that they can see what I can do and my abilities and my approach. But I am also, if I don't think any firm or firms would do this, like, hey, we want you for a blank number of cases to the exclusion of others, I would be hesitant to do that for two reasons. One, I don't want to be beholden in that regard. Two, it creates an impression of impartial, of being not being impartial or being partial to particular entities. So, especially as a mediator or arbitrator, I don't want to be known as, oh, he's beholden to these blank firms. That's just bad for business. Whereas if you're an attorney, you can be on the plaintiff side or defense side, and there's plenty of work in that space. I'm always amazed and flattered when somebody picks me as a mediator, which is like, to get two attorneys to agree to anything is flattering. And if they agree to me, it's like, that's great. And so I'm mindful of keeping not only that reputation, but I don't want that influence on my financial income in that regard either.
Mm-hmm. You mentioned something that's differentiates about you as process, the work that you're putting in. Is there something differentiates about your point of view about how mediation arbitration is conducted? Where do you think there are pressure points? Like, what would a reasonable mind, what are your counterparts disagree with you on that you think is a differentiated point of view that you have about how to resolve disputes?
The differentiating, this is, and again, there's a lot of great meters, so I can't tell you what other folks do. I can tell you what I've heard from attorneys who have hired me now. What they say they appreciate is not only the prep, but also I will give them a deliverable, in the sense of a mediator's proposal that I will send out is, it's not going to be like a paragraph like, you should settle for blank. Everybody needs to know the why. If you're settling a case for over $2 million and you got to go to your in-house counsel, they need to know why. Why should we pay this money, or why should we accept this money? And one of the things I try to do is always explain why I'm making a particular recommendation. That's sort of an extension of my job as from a judge, where I would write probably sometimes a little more extensively than I needed to, but I felt the parties needed to have insight into the thinking as to how I came to a conclusion. That allows the parties then to potentially look at that and say, well, we think Judge Kewalramani messed up here. We think he messed up here because these facts are not wrong, and that may change the valuation. But that allows then the parties to have a meaningful discussion after the mediation has ended and while I'm still involved. And so the thing that I try to do is probably provide an extensive deliverable to the parties that they can then rely on, if they don't resolve it then, to resolve the matter a little later as facts change, as circumstances change.
So I have two questions to wrap up here.
Sure.
One question, I think both are recurring themes on the podcast for lawyers. So one of the interesting questions or framings the lawyer might have for their career is strategy versus opportunism. And there's definitely a yin and yang aspect to those, and that each encompass a little bit of the other. But what, in various ways you've talked about, I'm hearing a strategy to decision making in your career. In other words, I'm also hearing opportunistic movement and action. Do you identify with one or more or the other, or do you have some resolution between the two? How do you think of that?
So your strategy has to change as your life changes, right? There's a difference as a 27-year-old attorney with no kids and no spouse that you can take more risks versus you have other responsibilities. You also learn about yourself as you grow, hopefully, saying what is important to you. What do you see as a strategy to say, okay, how can I get more clients? What's going to, as you've indicated, like what differentiates you from somebody else? What is going to be uh, important to a client down the road in order to get those clients as a lawyer? Uh, Not only performance are going to be table stakes. You have to win, you have to do well, you have to be responsive to your client. Those are all baseline. But how do you then differentiate yourself? You have to take a look at your own. Tried to take a look at my own strengths and weaknesses and found where could I maximize my abilities. Going back to the gym rat thing, I'm not 6'3". I can't dunk. Okay, I'm not going to play forward. That's off the table. Where do you fit intellectually, geographically, your platform that allows you to perceive in your mind where do you see a successful career 5 years down the road? And one of the things that I think it's very hard to do is predict where you're going to be more than 5 years from now. Life changes, but you should have a general plan, and then it gets hazier. And then you have to be open-minded to see, okay, well, does this opportunity fit within this 5-year strategy? There's one of the hardest things to do is identify the 3 most important things to you in life. I think I'm borrowing this from Stephen Covey or something, right? Or you write down the 3 or 4 most important things, and then how does every decision go to those things? But the hard part is identifying those 3 things that are important to you, and then how every opportunity fits within that decision. So I've tried to do that. I've tried to, from time to time, sit down and write what are the 3 most important things to me, and how does my decision professionally impact those 3 things, personally and professionally.
Yeah, it's an interesting observation, and the 3 things. That's exactly how my wife, who's my business partner as well, approach ourselves as well. We share the same 3 priorities around work, family, and business, and that means to the exclusion of things like travel, friendship, creativity. Which is not to say we don't experience any of those, but they have to align with those first 3. She and I also have different prioritization of those 3. But what I'll add to what you're saying, potentially it's a difference of opinion, is that I think what's hard. So I don't think we've had a hard time to identify those. I think we found a really hard time to apply those and really
Yes.
hold it up, because like that involves, again, trade-offs. That's something I keep on coming back to again and again. But yeah, I think that's an important observation you're making, and this ties into my other question for you, which is, we started the conversation the first time you and I spoke, about this podcast. You proposed this concept of nonlinearity. So then, you've been around the block. You've seen this, right? Like you've seen, hey, I've made moves, and so sitting here now, what do you see as prospectively the value of this experience for something else, maybe?
So prospectively, I think I continue, again, based on my life stage, where I am with our kids, with our family. I'm 54. I am continuing to keep an open mind. You never know what opportunities are going to come down the road. Again, how does that factor into your your top 3? So I could, if the right opportunity came along, for example, would I pivot from being a mediator and arbitrator at Jan's? Yeah, but I would have to think about. I'm not wedded to this is who I am. I am a former judge who is a mediator. It is not part of my identity. It is work is separate and apart from my identity of who I am, and that takes time and I think confidence to be comfortable with, because oftentimes in our society, as you know, people ask you, "What do you do?" as if that is who you are, and you have to be comfortable saying, "Well, what I do is blank, but that's not who I am." And so I am continuing to, again, when I say not nonlinear, I compare it to a lot of my peers who they haven't done plaintiff side work. They haven't done defense side work. They haven't worked at a big firm. They haven't worked at the U.S. Attorney's Office. They haven't been a judge. They haven't gone out to the mediation world. It's nonlinear in the sense that it's not common. Is there a through line to it? Probably. We can always draw a through line through everything, right? That's just statistics. But I continue to remain open-minded to opportunities, and I'm not, again, this is not who I am. This is what I'm doing now to fulfill those top 3 goals in my life.
Cool. Well, I'm looking forward to what you do with this chapter, and I'm looking forward to seeing what the next chapter brings you. So I'll be staying tuned.
I appreciate that. Thank you so much for your time. I really appreciate you giving me the opportunity to actually visit with you and get to know you better.
I appreciate that.